Welcome back to the Court Report. We'd like you to join our studio audience at the University of Victoria Law School. The details are on the website tvnz.co.nz, keywords The Court Report. Now we've got a fascinating story. I was very surprised when I first heard about it. It's about relationships. Most of us have them. Some of us even have a bit of paper that makes our marital status official, though many don't. And nowadays we recognise de facto relationships in just about all areas of law. But there's one exception: adopting children. If you're a de facto couple, the law says you can't. At least that was the case until a Wellington couple took up the fight and won. Their privacy is protected, but counsel Claudia Geiringer explains the family situation and how they work their way around outdated adoption laws to set a new precedent.
Well, the case concerned a couple, a man and a woman, who've been living together in a de facto relationship for over 9 years. They've been bringing up children together. The younger child is the biological child of both parents, but the older child was born before the relationship commenced to the woman using sperm donation. So the time came when the family wanted to regularise or formalise relationships within the family. The problem is that if the father applied for an adoption order on his own, then under the Adoption Act, all existing legal relationships are wiped. So the mother would cease to be the legal mother. So the couple needed to apply jointly to adopt the child. And this is where another problem arose, because the Adoption Act, which was passed way back in 1955, says that only spouses can apply to jointly adopt the child. So the question for the court was, are the two people in a de facto relationship spouses for the purposes of the Adoption Act? And the problem for the court is, of course, the court is bound by what Parliament says. They can't change the law, and so they have to ask themselves, how far could they push the words of that Act in order to bring it up to date to contemporary circumstances? So the court said, well, against that background, ultimately there was nothing they felt strong enough to prevent them from doing what was the common sense thing, really, and allowing a couple in this situation to adopt. Well, the family are absolutely ecstatic. They're delighted that they've been able to adopt the child. Having had this experience with the Adoption Act, that they're aware that the Act is, and I quote, an absolute dog of a law, and they feel that even though the judges were able to do the right thing by them, this decision still leaves the law in something of a mess, and that Parliament really needs to step in and do something about it.
The more you delve into it, the more interesting this case becomes, because not only does it tackle adoption laws, but it also highlights tensions between the courts and Parliament. Joining me now is Victoria University public law expert Dean Knight and one of this country's leading experts on adoption laws, indeed he wrote the book, Robert Ludbrook. A happy ending, Dean, but really should the family have had to go through this?
Oh, I think it's a shame that the family have had to wait so long and go so far to try and get this issue resolved. It's one of those issues which has been on the agenda in Parliament, and almost everybody within the family law fraternity have been calling for reform for many, many years.
Robert, there have been many occasions in the past when this issue has been drawn to the attention of Parliament, has it?
It certainly has, on at least 4 different occasions. I mean, the Adoption Act has been amended, but the problem is we have a 1955 Act that is so out of date that really all you can do is tinker around the edges, and Parliament, for whatever reason, has refused to grapple with the many faults in the current adoption legislation.
But this particular issue really just focuses on the single word spouse, doesn't it?
Yes.
And the interpretation that the Act had was that that was a married couple and not a de facto couple.
Well, in 1955, living in a de facto relationship was termed living in sin. I mean, I'm probably one of the few people here who was round at that time. And even the idea of students of different sexes going into mixed flats was unbelievable. You know,
hasn't the world
we live in a different era.
We've got the Property Relationships Act, which effectively puts de facto couples on the same legal footing as married couples. How many statutes are you aware of where spouse has been defined as including de facto couples?
Well, the Statutes Relationships Amendment actually affected over 100 different pieces of different laws and even more regulations. And the purpose of it was to remove all differences between people, whatever the nature of the couple relationship they were in. And astonishingly, the only act that was left out was the Adoption Act.
Well, you use the word astonishingly. Why on earth was it left out?
The government have never said why this was done, but my personal view is that there's a sort of homophobia, that people were terrified of the bogeyman that two gay men might apply to adopt a child, and they thought the public would not stand for that.
So Section 3 of the Adoption Act says an adoption order may be made on the applications of two spouses jointly in respect of a child. The interpretation Parliament had consistently maintained for spouse was that it meant a married couple, man and wife only. How did the High Court get around that clear wording of Parliament and that clear intention?
I think they acknowledged that that was the old meaning, that was the current meaning when you think of it in ordinary terms, but the real kicker was the influence of the Bill of Rights Act. Because in the Bill of Rights, the Parliament has told the courts that if you're confronted with legislation where you've got to determine what the meaning is, the courts are directed under important provision of the Bill of Rights to adopt the meaning which is most rights consistent. And by that we mean adopt a meaning which doesn't discriminate. And here we're talking about discrimination on the basis of marital status and also in relation to same-sex couples in relation to sexual orientation.
Doesn't the Bill of Rights Act also say that Parliament is supreme? That's
right, and that's the other thing, the rock and the hard place, if you like, for the courts. They're directed to try and give rights-consistent meanings and ordinarily update meaning to make it contemporary and speak for today. But on the other hand, they can't step on the toes of Parliament. And in the end, they said, at the end of the day, we think that direction from the Bill of Rights trumps the failure of Parliament to act and to change the legislation.
We're going to talk about this more. It's constitutionally very significant, but let's take a quick break. Because when we come back, I want to talk about the future for our adoption laws and what the case says about the tension that can appear between Parliament and the courts.